Well, in the interest of having as much time as possible, I'm going to start now and also give a very, very brief introduction. I'm Martha Minow. It is with great delight and joy that we welcome our colleague, David Barron, Judge Barron from the Court of Appeals for the First Circuit, who's here to talk about his brand new book, Waging War, The Clash Between Presidents and Congress, 1776 to ISIS. And he will be interviewed by our colleague, Daphna Renan. Both of them have the distinction of having worked at the Office of Legal Counsel in the Department of Justice. Both of them have the distinction of being much more captivating than I am, and so I'm sitting down.
Well, it's a pleasure to be up here with you. And David, you actually hired me into the Office of Legal Counsel, so I feel like we've come full circle sitting here together.
Proof I can make a good decision.
It's a really remarkable portrayal of the separation of powers just unfolding through history. And maybe if you could start us off by telling us a little bit about how you came to the project.
Sure. Well, first, thank you all for coming. This is great to have so many people to talk to about this, and to Martha for helping host it. Martha was actually instrumental in the book coming to pass. The origins of it really were around 2003 or 4, when, as some of you may remember, the first reports were coming out about memos being written in the Justice Department soon after the attacks of 9/11 that took a very expansive view of the power of the commander-in-chief. And at the time, I was teaching here and was intrigued by one particular line of argument in those memos, which was that not just that the president had broad power to act when Congress had said nothing, but that Congress actually had no power to limit him in the way that he would wage war. And that just seemed like a statement I hadn't heard before, and so I started to study whether it was true. And the more I looked at it, the less I found that seemed to really support it. And so I started off really focused on the legal question: what kind of powers does the president have as a matter of law? But by the time I got to writing the book, I really am not as focused on that question. It partly is because I had worked in the government as the acting head of the Office of Legal Counsel at the beginning of the Obama administration. And the office that had produced those memos that had said the president can act even in contravention of statutes in waging war was an office that I was now working in and was confronting a lot of those same questions. And out of that experience, I became much more focused on the question of what have presidents done when they've been confronted with a Congress that's trying to restrict them. So aside from what they legally could do, just what has actually been the practice? How have they handled that dilemma? And the book is really an attempt to write that up. And I say Martha was instrumental in that because one night, soon after I came back to the law school after having worked in the government, we were in New York, I think at an alumni talk, and I was talking a bit about my experience in the Office of Legal Counsel. And after it, I was walking in New York with Martha talking to her about this book project. And what Martha said was something like, tell the stories of what happened in the past, and I thought that was an awfully good idea. There's only one problem with it. It takes a lot of time to tell those stories, but that's really the genesis of the book.
And so your stories begin with George Washington, but the year is 1776. So you're giving us a kind of prehistory of sorts for a study of the allocation of power by the Constitution. So why is that your starting point?
Yeah, one, it's a great story, just to be honest. And the story is Washington in New York right after the battle in Boston. He's facing 100 British warships. He's convinced that the British are going to attack, and not just attack, but overrun his forces. And so what he's focused on is, how do I get out of New York, because I clearly have to retreat. What he'd like to do is burn New York to the ground before he retreats, because if he's going to lose, he'd at least like them to get nothing when they get into the city. But before burning it down, and he's the commander-in-chief appointed by the Congress of his time, the Continental Congress, which was a differently constructed entity, he doesn't just order the razing of New York. Instead, he writes to the president of the Continental Congress, and he says, is New York to be left as winter quarters for the enemy? Now, as lawyers, you can recognize that as a leading question. And he's expecting the answer to be, absolutely not, please burn it down. That's not the answer he gets. He gets a letter back the next day that forbids him from burning New York City to the ground. And Washington, by all accounts, obeys that directive. The significance of it to me is that Washington, although in a different legal context than the commander-in-chief under the Constitution, is the model for the executive that all the delegates to the convention have in mind. They know he's going to be president. He's both a huge comfort to the ones who are supportive of the Constitution, because it's a pretty good executive to put in, and a big problem for the opponents of the Constitution, because he seems like a popular, temporizing figure. And so a lot of the effort in ratification by the opponents of the Constitution who make their claim based on the dangers of the war powers of the president is really focused on getting people to look past Washington. And you can just see it in the way they argue in the Virginia Ratifying Convention, where they keep saying, yeah, Washington was fine, and maybe we'd be lucky to have a dictator like Washington again, but think about what comes after Washington. And I think that basic question, what comes next, is something that every president, in thinking about the exercise of their powers in this context, has in mind, which is why I also think it's such a resonant story for setting up the argument of the book.
And looking at that kind of prehistory, the setup, we see Washington reading these letters from Congress, and there's an extraordinary exchange that you quote between him and a captured enemy prisoner, where he says, "I'm not invested with the powers you suppose. It's incompatible with my authority as my inclination to contravene any determination Congress may make." And it's this remarkable moment because this is pre-Constitution, pre any formal allocation of powers. So what do we make of that? Is that law? Is it political leadership? Is it good governance? All of the above?
Just to get the story in people's minds, so he's now left New York, he's retreated from New York, he's followed Congress once with respect to the burning of New York, and a British high-ranking officer, Scottish high-ranking officer, actually has been captured by the Americans in Boston as being held by them, by a man by the name of Archibald Campbell. He's being held in the way that high-ranking officers at the time were held, which has meant that he had servants while he's being held. And that's going along fine until the British capture an American general, Charles Lee, soon after the retreat from New York. And so, in some sense, for propaganda purposes, the Continental Congress wants to retaliate against Archibald Campbell and to make a claim that Charles Lee is being mistreated. So make the British look bad, and then see, we'll do something bad to your guy, too. And Washington's ordered by the Continental Congress to basically put Campbell in worse circumstances than he'd like. He takes away a bunch of the servants. Campbell's appalled. He says, "I only have one." And he says that I'm stuck in a dungeon. Can't you get me out of here? This is a letter from the captured officer to the commanding general of the American forces, George Washington. And rather than throwing away the letter, Washington writes back to Campbell to explain himself and says exactly what Daphna just quoted. "I don't have the authority you suppose." He's characterized by Campbell in the letter as a dictator. And Campbell thinks, this is great. I've got a dictator. He'll get me out of here. And Washington writes back, "Don't have that idea about me." Well, what is the exchange? So at that point, it's in a way law. He's definitely making an assessment of the scope of his authority under the orders that he had been given by a high-ranking entity, the Continental Congress, pursuant to the commission that they were authorized to give him. So I think he understands it as legal in that way. But what's so reflective of a practice that the book tries to suggest has gone on since then, it's not as if Washington, after writing that letter, then just does what Congress wants. He immediately starts arguing to the Congress that, well, actually they're not treating Lee that badly. So if what you want me to do is retaliate for how Lee's being treated, I don't have to, because nothing bad's being done to the other guy. So he's now just doing law in the second way, which is construing the order he's gotten as to how to treat Lee. And through back channels and letters to Congress over the course of 6 months or so, he finally gets Congress to come around and agree to the prisoner exchange that Washington had wanted from the beginning, and Campbell's released. Well, that method of acting, I don't want you to think I'm a dictator. I'm not. I'm going to follow what they're saying. But I'm also going to try hard to get my way, is, I think, in many ways, the practice that you see president after president, in my view, when they're doing it most attractively. That's the behavior that's consistent.
So in some ways, in your telling of this experience and really the accounts throughout the book, it's a bit of seeing these interbranch dynamics becoming a legal dynamic, becoming a legal principle of the separation of powers, shifting from soft politics back into soft politics, but with courts and executive branch lawyers starting to come in and trying to translate it into law. So what's gained, what's lost in that work of translation?
Well, there's so many different actors that we could be asking that question of. So you could be thinking of yourselves. Right? How does the public, looking at this practice, think about it? Does it help you to think of these as legal questions, or is it better for you to think of these as prudential practices, ways of being that give you confidence in your institutions, or ways of being that make you worried about these institutions? You could ask it from the perspective of courts. Would you rather them be thinking of these as legal questions fit for their resolution, so you'd want them deciding it? Or is it better for them to think of these as political prudential practices that they try and avoid deciding? And the same thing is true of the lawyers in the government, right? How much should they really be thinking of these as questions for themselves or not? And I think one thing that can go awry in the way we think about this topic is we start with an assumption that it's obvious which of the two things it is. It's just politics, or it's just law. But what you see over and over is all of these actors negotiating with themselves and others is, which one is it? Right? Which way should I be thinking about it? Sometimes that means they try not to decide the question. Not because they're sure it's not a legal question, because they're worried it might be. And then they'd have to say something about it, which, quite frankly, they'd rather not do, because it's hard to know what the answer could be. And so there's a lot of running up to the line, backing away from the line throughout that you see many of the actors in the book doing.
And so both in your telling now and in the book, it seems like the role of ambiguity features prominently. Sometimes it seems more a feature, sometimes it seems more a bug in some of these interactions. But can you talk to us a little bit about how you see that playing out?
Yeah, I mean, it's certainly something that over the course of my time just engaging with the materials, and I think this is true of most people who spend a fair amount of time engaging with the materials. There's a famous quote many of you know from Justice Jackson in the Still Seizure case, where he says that, you look at the history and try to figure out what it tells you, and it's like trying to interpret Pharaoh's dreams. There's just, who knows exactly what was going on. What's great about that, and what I like so much about that quote, of course, he says that in a decision when he then goes on to decide the president can't do something. So it's like Pharaoh's dreams, but we go ahead and interpret them anyway, right? Sometimes. And sometimes not. So the role of ambiguity, to me, just came to loom larger as a reality. But I think, and I don't know if the right way to think about this is in terms of rules versus standards. I mean, you could just think of this not so much as ambiguity versus clarity, but rules versus standards. Because what I took away from the history is that as ambiguous as the answer might be in any particular case, there does seem to me like a clear practice, which is to recognize that these questions are hard and ambiguous and need to be wrestled with, rather than that there's a clear answer one way or the other, right? A lot of you may have in mind, when you think president, Congress, war powers, Congress is going to check the president. That would be the rule. if we had a rule that was favorable to Congress. But what does checking mean? Sometimes it means pushing him to do more than the president wants to do. He's the temporizing figure. So it's just complicated what even the clear thing would be. But I do think what seems transgressive as a practice in history is a full-throated, clear statement that we know who the winner of this fight is going to be at the outset. The Constitution gave it to the president, or the Constitution gave it to the Congress. More consistent with the history is attempts to avoid coming to a final showdown on that question. In that sense, it's embracing the ambiguity of it. That you asked, rightly, is that a feature or a bug? And that's a deep question. Maybe we'll get to that when I come back another time. No, maybe we'll get to it back later today.
But so that there's kind of power and constraint just in the ambiguity, in the give and take. And so one way to see that is that there is a kind of mode of accountability, a mode of checks and balances playing out. Another is to worry that law is legitimating without actually checking, that it is that the dance in and of itself creates an illusion of constraint rather than a reality. So what do we make of those two possibilities?
Well, I think it is legitimating. I mean, by design. The separation of power system is set up to legitimate the outcomes of that system. It's a very conscious design. It doesn't mean that by legitimating you will find them legitimate, or that they're immune from criticism. The constitutional structure also has a First Amendment, which is intended for people to criticize the outcomes of that process. But at its root, the idea should be that the decision coming out of it has joint input, might take a long time to get to, won't always come out straight, has to take a crooked route to get there. I mean, that's sort of the play. And that, I do think you see happening time and time again. And in that way has a legitimating effect. But that can yield decisions that therefore have a stamp of approval about them that many people in the country find wrong, horrifying, unconscionable. I mean, a whole range of ways that you could question it. But I think to look to the separation of power system itself as the means by which you will get decisions that will never look like that, that seems to me a kind of a mistake to think about it that way. I mean, you might say that's why we have a due process clause, that's why you have a First Amendment, that's why you have an equal protection clause. There are other aspects of our constitutional structure that are also engaged in the enterprise of trying to check what's done, not simply this relationship between the branches.
So part of the account seems to turn on this idea that there are active branches engaging with each other, and it comes across in powerfully across the historical stories that you tell, and FDR's experience is one really powerful experience. I don't know if you want to talk a little bit about it, of three branches, each highly engaged, each active in checking, pushing, trying to find paths to maneuver. And so is what we have today a very different picture? What role does polarization and gridlock play in the account of the separation of powers that you develop?
Well, one thing about it is there's definitely periods of non-engagement, even in the course of a war, a particular war, right? So the book doesn't mean to suggest at every moment of every second, all our branches are really engaged and working with each other in a dance. Sometimes one's asleep at the switch, just true. Or perfectly happy with what's going on, willing to let the other person, the other actor control things. But there are moments in, I would say, almost every conflict, and certainly every conflict of any duration, where the engagement occurs. And the book's really about those moments, how to think about them and what happens during them. The story in World War II, there's two. There's the run-up to World War II, but the one that I think maybe you're talking about where there's the most engagement is in 1942. And it's just a confluence of two events that are occurring side by side. One is the Nazi saboteurs case, Ex parte Quirin, as many of you know, where Hitler had sent saboteurs on U-boats to land on U.S. shores. They come out, then they're supposed to go into American cities and blow stuff up, including shopping centers and terrorism of that time, orchestrated by the Nazi regime to do harm to America. The saboteurs themselves turned out to be a relatively hapless lot. Most of them had some tie to America, so a lot of them looked up their old girlfriends when they arrived, which wasn't probably part of the plan. And they eventually get picked up by the FBI when one of them turns himself in after going shopping. And so the question, what are you going to do with them? Well, Roosevelt wants them in a military tribunal, and that's sort of the military commission case that's framed the military commission's debate that we've had during the current conflict. And in fact, that trial occurred in the offices that Daphna and I worked on, the 5th floor of the Justice Department. So that history's present for us, but I say that only because I think anybody dealing with these issues in the government, the history of it is very present with you when you're grappling with these issues. But in any event, the Supreme Court has that Nazi saboteurs case, and they're deciding it. They decide in a special summer session that the tribunal is legitimate. They bless it. They don't write an opinion. They say, we'll get back to you in October with the opinion. So they've now just sanctioned the outcome of that trial, and as it happens, they're condemned to death, so 6 of them are going to be executed. Well, they come back in October, and now he's got to write the opinion. Well, some things have happened in between, and the main thing that's happened in between is Roosevelt has just had a massive fight with the Congress, or contretemps with the public, however you want to put it, about inflation. And inflation is rising. He thinks it's the biggest threat to the war effort that their country's facing, much worse than any Nazi saboteurs. And he wants to stop inflation, and the question is, how can he do it? Well, he wants to cap farm prices in particular, and the Emergency Price Control Act, which had been passed, seems to not permit him to cap farm prices. So what's he going to do? Well, he's getting a lot of pressure, some of it self-generated, to claim the power as commander-in-chief to just order prices capped. And so he's thinking of issuing an executive order. There's lots of rumors. He's going to issue this executive order to just impose a price cap. As it happens, he's been advised by a sitting member of the Supreme Court you can't do that, which is odd for a sitting member of the Supreme Court to do that. Wouldn't recommend doing it today. So he thinks he can't do that, actually, but he doesn't want to say that. His lawyers have worked up a very clever and maybe even right alternative statutory argument that if you use a rationing system under a separate, recently enacted statute, you might be able to get the same economic effect. So Roosevelt doesn't tell anybody what he's going to do, but he has a radio address set, and he's going to announce his decision. So everybody doesn't, what's going to happen? Is he going to have a dictator going to take over the whole economy? Well, in classic Roosevelt fashion, he sort of suggests maybe that is what he's doing, but he also kind of suggests maybe that's not what he's doing. And he says, basically, if you don't give me the authority I'm asking for in, I think it's a week or so, I'll take the action I need to take. Then amazingly, in Congress, senator after senator, representative after representative gets up and says, we have to give him what he wants or we'll have a dictator. Which was just what Roosevelt was hoping would happen. And he basically gets the authority that he needs, and that sitting Supreme Court justice actually then becomes the guy who heads up the rationing program after it's established he resigns from the court. Okay, so that's all just occurred. Now we're back to the Supreme Court about to write its opinion on the Nazi saboteurs in October. And the Chief Justice writes to his colleagues and says, well, I'm trying to write up this opinion. I have a problem. It's not working. Because the procedures that they've used for this tribunal don't seem to match the procedures that Congress set forth in the Articles of War. Well, remember, they've already executed 6 of the 8. So he says, you know, this is what you call a problem. And what precedes is a debate within the court as to what to do. Justice Jackson writes to conference and says, well, this is easy. Congress can't tell the president how to set the procedures for a tribunal to try invading Nazis. That's ridiculous. It'd be unconstitutional for them to do that. The other justices say, wait a second. I'm not sure I want to say that. And a clerk to Justice Black says to him, by no means can you sign on to that language from Justice Jackson. And why not? Look what Roosevelt just was saying to the nation the other day about him being the dictator of the economy in deciding how we're going to structure all prices in the country under his war powers. If we write an opinion along the lines Jackson says, that's a green light for FDR to do that. And at the end of the day, there's a big back and forth between the two, and Justice Frankfurter writes one of the strangest memos, certainly a memo unlike I've ever encountered on the bench, and probably unlike anything any judge has ever encountered on the bench. It's called FF's Soliloquy. And it's a meditation on what he thinks the boys in the boats out in the field would think of the debate that's going on in the court right now. And he basically says, as my daughter would say, get over yourselves. You all agree that Congress intended for this tribunal to be permitted to proceed in the fashion it did. Why have a big abstract constitutional debate about who gets to decide this question? That's not going to do any good for anybody. And at the end of the day, the opinion's written in an incredibly vague way that brushes past these questions and avoids taking a position on either side. So if you just think every actor there is engaged in some running up to the line of really deciding the key question and then backing away from it, and also, and this is why these things are challenging, why probably a lot of you are here today, because this is the unsettling part of it. Also, things are done that, as you say, are legitimated, like the tribunal in Kieran, that raise grave concerns for a lot of people that the system could produce that. So it's that tension between sort of the case of the moment, the particular issue that you're faced, and the larger systemic questions that you really see all those actors, I think, thinking about quite deeply.
And then there's a question of, given that the kind of the power, the logic of the separation of powers plays out at that systemic level and not in the moment, then there's the question of how do you refract that into the decision-making in the moment, whether you're an executive branch lawyer confronted with a specific question, a justice confronted with a specific question. And so in a way, the book is a testament to the power of historical gloss. We understand, we learn about the separation of powers through your telling because of the way it unfolds through history. But it seems like it's also a challenge to it, because what does a lawyer do confronted with, in the moment, a specific question of the separation of powers?
Beats me. No, sometimes it's very hard to know, what to do. And I think a couple things that you see sort of characteristic of the practice that I think is responsive to the weight of the history is an instinct to decide these by statute rather than constitutional grounds. There's a feeling that the statutory resolution of the question is just more susceptible to change. Now, that could be not true, but I think there's that instinct, just a principle of constitutional avoidance, basically. But you see in case after case some way of resolving this that's not on the mega constitutional issue, but that, the Second War Powers Act actually gives me authority to have a rationing program if you look really hard. And that the Articles of War actually did provide a basis for these procedures to be used in this tribunal, rather than doing it on the big ticket, well, because the president wants to do it and he's empowered as commander-in-chief, that's the end of the story. I think that's the most consistent consequence of the very real concern that you identify.
Although in some ways, then it just shifts the problem to the level of statutory interpretation.
It does, but here's the thing that I think, and I end the book saying this, and I don't know if it's true, but I believe it. This, I think, is the practice, or at least my account is. This is how people have handled these situations when they've been in high office and charged with these decisions over the course of more than 2 centuries. For better or worse, this is what they've come up with as to how to handle it. And you can see in that it has generated an intense sense that we need to think about it legally. In other words, very few of these decisions are made without some consultation with the lawyers who get highly engaged in the matter, raise their questions, slow things down, provide focal points for debate, independent of the policy, etc. And that happens over and over. And I end the book by saying, which is I think all that I can get out of it, we know what the experiment looks like when you run it that way. We don't know what it's like if you ran it a different way. And I'm worried if the thought is, well, we know it would be better if it was all done in constitutional terms or with a greater degree of clarity. I mean, there would be benefits, no doubt, to it, but there would be real risks to the stability of the system. And in that sense, you know, going very much to the early debates over ratification, I mean, the Constitution says precious little on this topic. It says that Congress gets to declare war, gets to regulate the troops to some extent. It says the president's the commander-in-chief. I mean, you can't put those three things together and come up with an obviously clear answer by design. And everybody in the ratification debates understood that. Or at least every opponent in the ratification debates understood it. Right? This is not clear. And look what someone could do with it because it's not clear. True. To me, what's sort of remarkable is the answer back to them is it gives the structure. We know people can act prudently within the structure. Look at Washington. It'll work. And judged at least by the metric that they were setting it up, which doesn't have to be our metric today, but by what they were looking at, could you build a system that would be relatively stable and recognizable as one that has checks and balances, doesn't just give all power to one actor? 250 years hence, after a country's fought as many wars as it has, you know, I think by that light, pretty good what they pulled off. But of course, you know, one of the other features of the experiment is people constantly criticizing it for being a sham and a joke and a fig leaf and all of these things, which is really helpful that people do that, because that, you know, reinforces the actors in the system to feel like they have to honor it.
So if we think about the system less as any fixed boundary, but about this idea of available moves and counter moves, how important is transparency to that story? And is it a challenge today with the rise of classification in the way that we engage in war and national security decision-making?
Yeah, I think, I mean, it certainly is. And I mean, just one little vignette that to me, I think illuminates this point. You know, as many of you know, at the start of the Civil War, Lincoln didn't have Congress in town, which was good and bad. So he did a lot without Congress there. He calls Congress back on July 4th. And in the run-up to them coming back, he's preparing very, very hard for the speech he's going to give to Congress. And the whole idea is to get Congress on board with everything that he did, not to say, well, you missed it, it's my show now. That was not how he was putting it. So he's got his speech prepared. And in fact, there's a lot of maneuvering about how they're going to sequence the special session to make sure he gets the ratification bill that he's after. The very first bill introduced, SB 1, is a bill to ratify all that he did. As it turns out, it takes the entire session to get that thing passed. All kinds of fighting goes on. They're very worried they're not going to get it at all by the end because Congress is giving them so much trouble. But Lincoln, in trying to figure out how to proceed, makes a pitch to Congress in that speech in which he is pressing them to ratify what he's done. And he's candid. Oh, I did this without your authority. I did that you might think is illegal. I did this thing that I had no authority to do. But there's one thing he doesn't mention. He had sent a group of men on their own to do sort of private work in the South to do deals because he didn't trust his own Defense Department to do acquisitions. So he's got a sort of an off-the-books, secret funding scheme going on. Well, he does not mention that. It just so happens that's the one thing nobody knew about. So when you call up 75,000 troops, you cannot keep that secret. And if you suspend habeas corpus, you can't keep that secret. So when there were comparisons to the Bush administration having not disclosed various things that were secret programs, to Lincoln and his forthcoming statement about all the things he had done, I always thought it was not quite a fair comparison. And that just highlights the point, the more war is carried out covertly, the greater the challenge is for this dynamic to engage at least as many actors as it otherwise might. Just the last point on that, though, one thing that just is very familiar in the history, at least as I tell it, in every circumstance, the question arises, isn't the new way of fighting war one that makes it impossible for us to continue with this practice? It arises when they first are faced with the quasi-war with France, with obviously they're against a great power. They're not thinking of just internal rebellions. They're talking about having a fight with a major world power. It arises in the Civil War, which obviously is a different kind of conflict with a different kind of challenge. It arises in World War II, when all of a sudden the concept of total war arises, which raises all kinds of questions about, can you still have this system when you're dealing with the concept of total war? It arises in the nuclear age with Korea, and it arises in our current age, I think, in this form of both non-state actors. Does that change things? Asymmetric threats. And also because of secrecy, does that change the nature of it? So the question of whether we're dealing with something new that requires us to change is an old question. But it doesn't mean that you have to give the same answer. But I do think it's worth just reflecting on the fact that the seeming newness of our situation may not be quite as new as it is.
And the approach of the book is very much to illuminate the recurrence of some of these questions and describe instead of judge what unfolds over time. But how do we evaluate it? How should we evaluate this practice that is described in different contours in different ways over time? And does it have failures that we can learn from?
It certainly does. I mean, I guess at the biggest, a million miles out, looking down at the practice, two things to me, I think, just that worry me if this was how people thought about the practice. One is a narrative which just insists that the practice is meaningless. And Schlesinger and others with the imperial presidency and that narrative, it's very attractive. I don't deny that one can't make the case for it. Effectively, the president gets to do what he wants. Isn't that what every example shows? The power of that narrative worries me because I'm not sure that the people who voice it are fully aware of a potential effect of that, which is not to induce checking, but instead is to give license. That's just the way it is. There's nothing other than that. And that does worry me if one drew that lesson from it. So that's the first. The second is, and some people in the mid-2000s started to make this argument, that because the constitutional system is ambiguous, that means it was designed to let the president have maximum power. And you could see how you could make that argument coherently. To some extent, the book is trying to suggest, look at all these people who thought the ambiguity didn't tell you that that was what the design was. So it's not to say that the practice is inherently the best. It's to say that as against those two alternatives, which is the ones that I perceive most present, I think it's important that people understand this one as an alternative, because I think it's most reflective of what we've had.
So to understand the process of kind of unraveling the ambiguity as its own form of systems of constraints, both internal to the executive branch and in the relationships and dynamics between the executive branch and the other branches.
But there's a deep problem with this enterprise in the following sense, and I mentioned it earlier, and I've thought about it. I've been on panels with Jack Goldsmith, who many of you may have taken a class with, who was a head of the Office of Legal Counsel and a great head of the Office of Legal Counsel. And we've talked about this issue, and the problem is this, which is if everybody just sat back and thought, well, they're having a little dance, it's good. I'm glad that they're doing that. Makes me feel good. That wouldn't be good. I mean, that would be worrisome, right? Because it would legitimate these actors. The dance is in part a product of the forces from outside constantly saying, President's being too weak, he's too passive. What kind of commander-in-chief is that? And on the other side, people saying, we have a dictator, he's an imperialist, he has to be stopped. Well, that conversation is what's producing also this interaction by the actors, because they're sensitive to the pull of those claims. I mean, you really can see Ford. I mean, it's really just in a remarkable situation, Gerald Ford. Doesn't get focused on as a heroic president, but if you think about what he's facing at the end of the Vietnam War, Congress has legislated the end of that war. They've taken away his powers to do combat operations. He has to get Americans out of Indochina in some way that's going to be plausible and honorable. And how is he going to do that? And he's doing that at a time in which trust in executive power is at zero, and he understands part of his job is to restore confidence in the presidency. And he's also doing it at a time in which everybody's starting to criticize him for being weak. And his way of negotiating through that, I find pretty impressive and remarkable. And, as proof of that, not that long after he's done, a fair amount more respect, confidence in the presidency has come back, which was not obvious that could be accomplished. But that's just, I think, just a particular instance of the way in which these outside, more extreme ways of characterizing it are really, really important to getting people inside the system to act prudently rather than in extreme ways.
And so you mentioned Jack. Do you see in the current instantiation of the separation of powers, is the role of civil society a key one?
Yeah, no, I think it really is. And every one of these stories, they're all sensitive to it. They're all being criticized constantly. Robert Jackson, when he's the Attorney General for Roosevelt in the run-up to World War II, and he's responsible for the legal theories that enable the Americans to lend destroyers, ships, to the British at a time when Churchill says he desperately needs them or the Nazis are going to overrun Britain. Very, very controversial. Takes months of back and forth to come up with a legal theory that anybody has any confidence in within the administration. They come up with the legal theory. They produce the opinion. Roosevelt says, you're definitely publishing this one, because if anybody gets yelled at, it's you. Jackson releases the opinion, and he's trashed. Not by everybody, but by some people. In fact, Wendell Willkie, who's going to run against Roosevelt, first comes out and says, this seems pretty good to me. Then everybody yells at him. He comes back, wait a second, this is the most dictatorial opinion I've ever seen. But among the people criticizing him is Edwin Corrin, famous professor at Princeton, who says basically this is the opinion of a dictatorship. And Jackson doesn't just slough it off. He writes an answer to Corwin in which he says, if you saw what I saw about all the back and forth in the government and all the different ways we thought about doing this and all the compromises that had to be made and all the ways that the deal was shaped and changed over the course of the time. And he says something like, eminent authority notwithstanding, real kind of put down of Corwin, this is not autocracy. So he feels it. which means he felt it as he was working on the issue, as I think he very much did. And I guess another point of the book is, as I think anybody should, who's in these positions.
And then talking specifically about Jackson, who figures prominently in the book, does he then approach the same questions differently as justice? How does the change in role from attorney general to
it's
to
hard
justice?
to, and I'm not a scholar of Jackson, so I don't know, but just the things that are just surprising. He writes the great opinion in the Steele seizure case, in which he, explains the basis for checking a president during a military conflict. He doesn't quite call it a war in the strict sense. But he also writes that draft opinion in the saboteurs case. Now, some people have said he liked Roosevelt, he didn't like Truman. I don't know if it's as simple as that. Or maybe he liked World War II, he didn't like the Korean War. Or maybe he thought they were different cases, or maybe he had learned something. But it's hard to know exactly what his mindset is.
Well, I want to give a chance for questions from the room, so we have a few minutes left. Dean Minot.
Well, this is fabulous. Everyone should buy the book, read the book, and I want to thank the library for hosting this series. The use of precedent. So again, it's fabulous. Everyone should buy the book, and thank you to the library. The use of precedent, of course, is the telling of stories. But what this book does is it goes way beyond what we get in court. And it makes me wonder about what could be the authority of the kind of stories that you tell. And maybe you can say something about how the Office of Legal Counsel uses the history, but also looking forward, how should the full history be used as part of the practice that you described? And if you want to forecast something about President-elect Trump, that's great.
I don't. It's a good question. I mean, I think, and I don't have a great answer on how courts should use history. I don't. I do have a thought, though, about how those in the executive branch, and maybe those outside the executive branch talking to people in the executive branch, might use it. And it's really on two levels. In the executive branch, lawyers in the executive branch conceive of themselves, I think, and even the titles they have, counselor, advisor, attorney general, they're not courts. They don't think of themselves as judges. They're not tribunals. It's just not what they're about. They're giving advice, not just to a client. It's not how they think about it either. I think if they're often doing it right. They're advising on difficult legal questions for the United States. I don't know who they're advising. They don't know who they're advising sometimes. But they're trying to give good advice for the United States. And in that regard, what they're thinking isn't just thumbs up, thumbs down, can you do it? It's what would be good advice to give you legally about how to proceed, given what you want to accomplish, given our sense of what would be legally controversial, given what might get you in a lot of trouble, given what might be a precedent that some other person would use that as a lawyer I wouldn't want to be responsible for having stood behind, et cetera. And the stories, to me, I think, are most helpful in reinforcing my sense that that's the enterprise they're engaged in. It's not just legal decision-making. It's not legal opinion writing in the way that you might think of it in the case books that you read when you read appellate decisions.
I'm curious how the dynamic and the conversations that happen changed in the shift to a large standing army that at this point we fund at sometimes kind of insane levels. Consistently, there really isn't a serious conversation about how much we're going to tinker with that. We just accept a large standing army that is always well funded. A little bit of difference on OCO funds, but nothing at the base budget level. How that changes Congress's leverage.
Yeah, well, it reduces it. And they were very aware of that, at least from the debates you see over the quasi-war with France in the 1790s. Because what John Adams, the president at the time, was saying is, I need a standing navy. I guess you don't have a standing navy, a floating navy. And I need it to protect the country, so I need it in advance. And I need all kinds of authority to start sending out persons to protect the U.S. merchant vessels that'll go out. Well, Congress is very worried about giving him this because once he hands it over to him, it's just a fact. He could send that ship out, and if the captain of that ship has no judgment and encounters a French vessel and starts shooting, and the French fire back, you just are at war. What's Congress going to do then? They recognize that. So there's a real fight in Congress in that early stage about what Congress's authority might be to put restrictions on where those ships can go if they give it to them. There's a statute that they have to hug the coasts. And a big debate about whether you can tell the president that or not. And it's just reflective of this worry, because they recognize two things. One, we have to give them forces in advance. And in a world in which things operate quickly, all the more reason you have to do it. And also, we recognize the lack of leverage that means we have once we do that.
Since you first conceived the book, you've occupied a few different roles. So I wonder if you could speak about how that has influenced
Shaped it, yeah.
Tone, or maybe now as a judge you're a bit more constrained.
Yeah. I mean, it probably makes me less judgmental of the people acting. I mean, it's not all that appropriate for a judge to be announcing super strong opinions about anything other than in their opinions. So that I'm sure that has some effect. But I think also just having worked in the executive branch had an impact in the sense that I just got more interested in the people who had to make the decisions and their thought processes in making them than in the outside evaluation of whether what they produced is correct. It doesn't mean you shouldn't be interested in that, or that's not interesting. It's just what I wanted to talk about. And I thought it was important for people to see that. Because I think that's worth evaluating in its own right. You know? I mean, there are times, and I think this is true of anybody in the government, you're in a room and you honestly believe, gee, I think if people saw this happening, they'd feel good about their government. That people were thinking about this way. Even if they didn't like the decision at the end, they'd think that was a pretty, there were real trade-offs. It was really hard. And there are times, and anybody who's been in the government knows this too, you've been in the room and you left that room and you thought people would not feel good about their government if they heard the conversation going that way. And the modest hope of the book is to sort of lay this out on the thought that hearing more of this will add in some way to a culture in which those conversations occurring in the government are more like the ones you'd be proud to have known happened, and less like ones that would be, deeply disturbing to you.
So I wanted to give you a chance, if you want, just a couple minutes of concluding thoughts.
What, did you have one? You can ask if you want.
I noticed that the subtitle of the book is From 1776 to ISIS. And so I wonder if I could bring you to the present day.
Yeah.
Thank you. In particular, President Obama's decision after setting a red line for use of chemical weapons in Syria, the president indicated that he would use force, and then decided after the UK Parliament decided not to authorize force, or the UK to get involved, that he would not authorize force or use force here. I wonder, how does that fit into sort of the overall narrative of how presidents have approached that problem, and whether that decision is perhaps a concession then to the Congress that may have application into the future, and also perhaps how the evolving justification that we now use as a continuation of the AUMF or mutual or self-defense from Iraq, how that sort of plays into how this may operate in the future.
Well, a lot has been written about the power to use force in the first instance. And that was the subject of Schlesinger's book on the imperial presidency almost exclusively. And people are still, rightly concerned about that question. This book focuses less on that question and more on how do you conduct a war that's ongoing once it's underway. And partly the reason I got interested in that question is because, at least when I first started writing the book, there was pretty clear authorization for the conflict that was then ongoing following September 11. It's been, I know, become more controversial whether it's been stretched in ways that aren't really tethered to that. But at the time the book was conceived, that was less of an issue. And the Iraq War was the other war that was going on. That was plainly authorized by bipartisan majorities in the Congress. And yet, there were huge war powers dilemmas. And they all concerned how to fight these wars, who got to control the way they were conducted, rather than whether to have them at all. And the thought was that we're in a period where there will be still debates about the scope of the authorization, but there is also, seems to be, pretty strong consensus, at least in Congress and the executive branch right now, for some relatively robust authorization to use force, whatever its bounds. But I think that's unlikely to put an end to questions about how to conduct it, because throughout our history, issues about that question have also arisen as sources of fights between the President and the Congress, and that's sort of the thing that I wanted to highlight.
So if the idea of the separation of powers is having that broader systemic understanding of how it evolved over time, you've equipped us with a much deeper understanding than we had before your book. So thank you so much.
Thanks, Daphna.